Welcome everyone to this Privacy Espresso. Today we are going to have a special edition of it because we are going to speak about a very recent update from our Russian members. We are speaking today with Sergey Medvedev and Stanislav Mintsev from the firm Kuroditsky and Partners in Russia. Thank you very much both for being with us today. And let's move quickly because time is really short and we have a lot to say about this new alert. There is a new law from Russia and we would like to know a bit more about these new regulations. So Stanislav, I would like to start with you. What is this law about and when it entered into force?
The new law entered into force beginning from 1st of July 2021, so it's already in legal force, and we call it the law on foreign companies. So the main idea is that according to this law, some companies doing business in the internet or basically having websites must comply with certain requirements of the Russian legislation mentioned in this new law. And if they don't comply, there may be certain, I don't want to say liability, but certain coercive measures like blocking of websites and things like that. So before this law, many companies believed that they exist outside the Russian jurisdiction. And this law attempts to bring these companies into the Russian jurisdiction.
Okay, perfect. Stanislav, and to you again, to what companies does this law apply?
There are several criteria to identify these companies. So for now, I can explain you only on the basis of the legal text because there is no case law or official guidance by the Russian authorities. So there may be some slight changes here, but according to the literal interpretation of this law, the law will apply to hosting providers if they host websites used by Russian users. The law may apply to so-called organizers of data dissemination. These are the websites or mobile applications or software if the users from Russia can use this app or website for sending messages to other users or posting some content. And if the users have accounts on these websites, then they're called organizers of data dissemination. So the main idea is that such resources help people to communicate. If in this case, if they allow Russian users to use them and send messages, then the new law may also apply. And in addition to that, there is an applicability test for all other web resources. So basically, the new law may apply to any other website or mobile app if it has more than 500,000 users from Russia daily, plus there are some additional criteria, or at least one additional criteria. The additional criteria says that the website should have the content in Russian, or there may be advertisements addressed to Russian users, or the foreign company owning this website may accept payments from Russian users or from Russian legal entities. So the main idea is that the website should have 500,000 users plus, from Russia, plus this website or app should be somehow intended for the Russian market. So it should be clear that the business strategy of the owner of this web resource includes the Russian market.
Okay, that was really clear, Stanislav. Thank you very much. And speaking about the law, which are the main requirements?
There are several requirements. First of all, the owner of such web resource must register with the Russian authorities and create an account with the Russian authorities. This account can be used for communications with the Russian authorities. Also, beginning 1st January 2022, it will be necessary to establish a physical office in Russia. In addition to that, the Russian cybersecurity authority called Roskomnadzor will hold a register of such web resources to which the new law apply. So it will be necessary to register a web resource in this register. However, neither accounts with the authorities nor the register are available yet. So for now, they don't exist, and you cannot do it right now because the authorities are not ready for this new law for some reason. In addition to that, such web resources must comply with the personal data localization requirement that we discussed on the previous events. So before 1st of July, it was unclear in which situations this requirement must apply. So some companies believed that they should not comply with this requirement because the Russian law did not say clearly that they must apply. And now the situation is different because the applicability test is very clear. And if the company falls under this new law, then by default, it must comply with the personal data localization requirement. And finally, such companies must delete or block certain content that is illegal in Russia, and also comply with the court decisions and decisions of the Russian authorities. There are also some more requirements, but these are the main requirements.
Okay, I understand, Stanislav. Thank you very much. And I think we can move a bit also to Sergey, because among the requirements we were hearing about, there is the need to open an office in Russia. So I think that the question I would like to make to you, Sergey, is what does it mean to open an office in Russia?
Thank you, Alessandro. So it means that you have to open a legal entity or a legal presence in Russia and ensure its functioning on the territory of Russia. So there are three options that you can usually choose between. It's branch office or representative office, which basically repeat the functions of the main company, or you can have the option to open a subsidiary, like a limited liability company, for example, and this is a separate legal entity that will be functioning in Russia. As Stanislav mentioned, according to Article 7 of that law, this particular office must be ready to receive and process communications from Russian state authorities. They must be active and present in court and be able to enforce the court judgments and the court orders. And they must also be ready to delete or block illegal content, because the law is, again, also captures certain content which cannot be presented online or on the internet. So it must be ready to do that. Again, it's not just about the opening, it's about further functioning, as I mentioned. Therefore, not only the legal start is important, but further consequences like opening the bank account, registering as a data operator with the Roskomnadzor, the Russian IT regulator, file some applications with Federal Statistics Service, social fund, pension fund, be ready to be active as an employer. So it's about a couple of actions to be made.
Okay, perfect, Sergey. Thank you very much. And speaking about again about the offices in Russia, is there any preference on the legal for which to appoint the office? So like a branch or representative office?
So the branch and the representative office, since they are not separate legal entities, but they are considered to be standalone unit of a foreign company. Usually, some prefers to do that because you can physically create your presence in Russia. But there are some difficulties in terms of accreditation and registration. It's a bit more complicated comparing to registering a subsidiary. In terms of liability, I would say that separate legal entity or subsidiary doesn't bear liability of the parent company, while the rep office or branch office, since it's basically the same parent company, they will be liable in case something goes wrong. In terms of taxes, there are some privileges for subsidiaries. There is some simplified procedure which you can use, and you can pay, for example, 6% instead of 20% to the budget, while for branch offices and rep offices, there is no special simplified tax regime. As well, we say the client must choose comparing all these legal requirements, but usually these three will be the options as I mentioned.
Okay, and Sergey, again, how long does it take to create an office, to open an office, and how much it can cost?
Okay, we can again divide into branch office and rep office, which is about 2-3 months in total for accreditation and registration. For subsidiary, I would say it's about 1 month, 1.5 months, which is a bit more expedited procedure. In terms of state fee, it's about $50 for subsidiary, 50-60, and about $1,600 for a branch office and rep office. These are the state fees, but then you have to pay some legal or counsel fees, which will arise because the lawyers will work, and those will usually depend on the firm you can choose. Gordiski is the best, so please choose us.
Perfect, Sergey. Thank you very much.
We'll provide the best fees.
No, very practical tips indeed, including the one on the tips, but it was really useful, I think. And I have just one last question that maybe I can ask also to Stanislav. That is, Stanislav, we were speaking about liability. So what's the liability for non-compliance?
Well, as such, there is no administrative fines or imprisonment or things like that. That's why for today, I cannot say that there is liability for the non-compliance. However, there are coercive measures. It means that the cybersecurity authority may apply certain measures without any recourse to court. So they are non-court measures. And the authority, depending on a particular breach of the new law, the authority may block access to the relevant website or mobile app. The authority may prohibit any payments from Russian natural persons or legal persons to the owner of such web resource. The authority may also prohibit collection of personal data within Russia for a particular data controller, as well as the cross-border transfers from Russia into the country where the relevant data controller is located. In addition to that, the authorities may prohibit or restrict advertising of some web resource within Russia. And they may also restrict the publication of information about web resource by search engines. So when a user from Russia will try to find some website using a Russian search engine, then it will be impossible because there will be no information about this web resource. So there are also some additional measures, but these are the most important measures. I would say that in simple terms, it means that if a non-Russian company has some commercial project in Russia, and this project includes sales of something, then of course this company should consider this new law, because the business may be completely stopped with these extra court measures. If the company has some, I don't know, informational resource or social network or things like that, then of course the users can bypass the new law with the VPN or some other solutions like that. So some companies may rely on these bypassing ways, but still even such business can be substantially suppressed with these measures. That's why they're really important, I would say.
Okay, perfect. Thank you very much.
One more thing to add, Alessandro, I'm sorry. I forgot to say that the date by which the office must be opened, as Stanislav mentioned, with regard to commercial project or real business or physical presence, that's the 1st of January 2022. So we are in a rush because it's not too much time left. And as I mentioned, the timing can be about 3 months. So you also need to prepare some corporate documents like a charter, like a decision to open the office, corporate decision, etc. Meaning that we have to be in a rush, and I'm very serious on that.
Yeah, no, absolutely, and that was going to be exactly my question on this, because that's fundamental, and the time is really strict, less than 6 months, I would say, and that was extremely useful and extremely interesting. So thank you very much to you both for all the insights that you have been providing us today. And we really look forward to host you again very soon. And I would like to thank all our listeners for following this session. And I would like to say hi to everyone. And thanks again, Sergey and Stanislav, for being with us. Stay safe, you all.
Have a great day.